entertainment of these parallel proceedings itself was wrong, because once the first Section 9 was in the jurisdiction of Punjab and Haryana High Court, there ends the matter.
My lord, may I just point out one last fact, my lord? If I'm not being able to persuade my lord on 115 and on this aspect, may I just place this, my lord? Lastly, my lord, in BGS Soma, my lord, it has been said wherever the seat is not defined and the venue is defined, that is the court which will have the jurisdictional right.
Therefore,
My lord, in this,
accepting that, if you had a choice of two and you made your option by filing your Section 9, the first Section 9, on 14th May 2015, your fate stood settled there. That's all there is to it. All facts, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, the specially petitions accordingly dismissed.
my lord, may I seek the liberty to withdraw it then, my lord?
No, we do not permit withdrawals, Mr. Yadav.
Very well. Thank you. Very kind of my lords to have heard me. Thank you.
28. 28.
Am I audible, Malaz?
Yes.
Malaz, award, the question framed is at page 127, Malaz.
One moment.
Please, Malaz.
Yes. Yes, Mr. Balbi.
Please, Malaz. Malaz, the question framed by the tribunal is at 127. For a minute, my lords can kindly see.
Yes.
First question in para 22, Malaz. Whether the claimant retired from partnership deed after receiving 1,65,000 from the respondent. This was the question frame, or the issue number 1. On page 129, after examining everything, and particularly 2-3 paras on 129, middle of the page, from perusal of this retirement deed, that's how it starts in finding, on maybe 8th-10th line from the top. From perusal of this retirement deed, that's how it starts.
Page 129.
Yes, Malaz. This is a finding on first issue. From perusal of this retirement deed, it is clear that... I'm sorry, Malaz have got it, Malaz?
Page 129 on perusal. I don't find it there.
Malaz, it's 8th or 9th line, middle of the line, from perusal of this retirement deed.
Oh, from perusal. All right. I was looking for on perusal. Very well.
Oh, I'm sorry, Malaz. I'm sorry.
From perusal?
From perusal of this retirement deed, it is clear that nothing was paid by respondent number 2 to claimant. Though claim of respondent number 2 is that rupees 1,65,000 were paid to the respondent number 4 and the claimant, it is the case of the respondent number 2 in his cross-examination, which will be decided later on in detail, that the accounts were settled by the claimant. It is admission of respondent number 2 in retirement deed that all the records shall be with the respondent number 2 and other respondent. If the account was settled, it should have been placed on record, which respondent number 2 failed to do so. Very material facts have not been mentioned in the retirement deed, etc. That the amount of 1,60,000 was paid. My claim was that the retirement deed, which was not acted upon because I was never paid this amount, based on this, I succeeded the tribunal to say that I have not retired from the partnership. 34 court, Malaz, frames a question which is completely
retirement different. Deed is signed by you.
Yes, it is. I'm agreeing.
Wait, 1235.
1235, Malaz.
155.
155.
Para 41.
Apart from. Just see it from apart from.
Rather, if we see 154 for a minute also, Malaz. 154, para 37. It is by 34 courts.
Mr. Balbir Singh, wait a minute.
Sorry, Malaz, sorry.
Then
Page 155 and 156, where you
Malas,
admit your signatures on the retirement deed.
yes, yes, Malas, this was always my case. My
No,
case
but
was never.
Your
Kindly see,
claim was that you had signed on some blank stamp papers.
that is the
So on the
subsequent
face
form.
of it was not believable at all, because given
Yes,
the
yes. I'm
atmosphere
not.
there, you would hardly have signed on blank signed papers when your
No, I'm
mother
not. My
was
case is
having an
not.
issue there.
Well, kindly see the question framed by the now High Court, para 37, page 154. My case was never that the deed was not signed. My case was that deed was not acted upon. 1,65,000 was not dispersed to the partners who are retiring. As a result, the partnership sustained. What 34 court frames is para 37, Malas.
Yes.
Thus, the principal question to be addressed by the arbitral tribunal was whether the BK IM had signed any blank papers which had been subsequently misused to reflect his retirement. This is not the question. I never claimed that. This was
Then
in
his claim is
context
for
to,
the money.
What was your claim for then? Let us show it.
yes,
Let us
yes,
see your
Malas.
claim.
That's the reason my claim
Let us see
was.
your claim statement. What exactly did you say?
Malas, I can read from the award if my lords kindly allow
Not
me.
file a copy of the claim statement. Very well.
Malas,
Let
I
us
can
see
file.
from the award itself.
Malas, if we can come to
Award also is not there.
well, the award is there. Award is there.
There?
That's the
No,
question.
If it has been filed,
One page.
Part of it deals with your claim. Let us see.
Yes, page 125, para 17, Malans, and 17 onwards is what I have said. And probably the confusion which created was the form 5. My case is not a form 5.
No, but your claim seems to have been that you are continuing as a partner there.
Yes, that's what
On
I'm
one
saying.
hand, you say that I never signed a retirement deed. I signed on blank paper.
just see 116 and 117.
Kindly see one page 125, para 17.
One 116 and 117. This is what you said. Never discussed with him about the retirement from the firm.
Yes, so I just to clarify what the confusion is created about the unsigned.
According to claimant firm. Not
Para
carried.
17 on page 125.
So you could have only asked, sued for the amount which was due to you under the retirement deed. There's
No,
no
but
question of your taking these kind of contradictory pleas that I never signed a retirement deed. I signed on blank stamp papers.
I
And
signed.
then saying that no, this amount is due to me.
No, this was never a case because this partnership we are existing is the second generation partnership. The parents of the partners were partners. I'm partners for generations in this. What was decided was that if you want to page
We are not inclined to interfere with this. Mr.
page
Please.
125, kindly see
Both the
only
34 court and 37 court held against.
the wrong question framed. Absolutely. I'm making a statement. My claim is not that the deed was unsigned. Deed was signed. It was a form 5 which was the unsigned, Malas.
बैलून्स जो जा रहे थे अभी वो उनके तरफ से होता है या अपने तरफ से होता है?
Malas, it depends on who punched that because there is a one icon which
You seem to have done it, Mr. Balbir. So I was wondering why you're sending up balloons when we are about to dismiss your case.
Well, I have not touched that. So possibly my lords are using something which the balloon, and I have not seen it was visible to my lords. So possibly the screen working in my favor, I would say, Malas. First to clarify.
There's nothing here to interfere with.
I'm first of all, the question which has been framed by 34 court, I'm admitting right from the day one. It was this document of deed which was signed by me.
Oh, you were not very clear as to what you went before the arbitrator with. You deny your statement, then you say my amount is due under the same document.
No,
so the arbitrator is also left clueless as to where he should go.
The award is very clear.
That award was doomed from the word go because of your lack of consistency.
The award is in my favor. So let's me make it clear. The award is my favor.
What is in your favor, no doubt. The 34 and 37 both held
Yes.
against you there.
My finding will come from page 125. Only two paras. Malad. That will make it clear. Page 125.
Yes.
Para 17.
Yes.
According to claimant, he is still legal partner of the respondent number 1 and entitled to all assets and properties of the respondent number 1 as per the shares in partnership deeds. 18. Now this is important, Malas. Defense put up by respondent number 2 in his affidavit in evidence as well as in reply to claim petition is that the claimant, having retired from the respondent number 1, has no concern with the assets owned by it. According to respondent number 2, at the time of retirement, account of the firm was settled and amount due payable to the outgoing partner were paid. According to respondent number 2, claimant and respondent number 4 were each paid a sum of rupees 1,65,000 on retirement. The retirement deed was drawn on 19/1, which was duly signed by the claimant and respondent number 4 on 19/1/2020. My case was this deed, which was signed by two partners, they never retired because this amount was not dispersed. The accounts were thereafter maintained continuously.
Once you signed it, if the amounts were not returned to you, then you file a suit for recovery of money.
Because subsequently accounts are maintained based on a partnership deed share. I still hold 33% share in that partnership.
However, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions accordingly.
Very well. 58.
May I please, Lord? This is a contempt petition similar to what Malord had decided on the Telangana matter.
Who appears for the respondents?
The office report service is complete by all modes.
My lords, we've just filed a wakalatnama today. I'm awaiting instructions. I'll file my affidavit in a course of 2 weeks, my lords.
I'm slightly opposing
which
that.
we have referred to. We have referred to a judgment in the notice order.
Indeed, my lord.
My lords.
That
For
would
this-
fairly apply to you, so you can advise your clients
My
accordingly.
lords, I will. My lords, 2 weeks we'll file a compliance most likely, my lords.
When counsel appearing for the respondents. Takes time. Yes,
But
yes.
Yes, I just want to make one request, my lord. Post the summer vacation, the next academic session will start. So all that I'm requesting is this, my lord, because the order originally was of October 25, had to be complied by January. Of course, review petition, etc. I won't take my lords again through that because in the Telangana matter, my lords have seen. Can I just request, my lord, that kindly give me a date this side of vacation so that they can report compliance? Because if it comes after vacation and do compliance after summer break, I
That
will
would
lose
give
one
the
academic.
council only a week's time then.
But
My
can
lords,
you
we
do
have
that?
it on Friday, my lords, the last day of vacation.
That's
I'll
a very
file
fair
my-
submission to make. Lord.
Yes,
I'm grateful
sir.
to my learned friend. Lord, and one
29.
query, my lord, had put that those balloons come because of the victory sign. Whenever there'll be a victory sign on Apple, my lord,
I
by
see.
anyone, so the balloons will come. My lord had put in the last matter, why were the balloons coming?
I did not make a victory sign, and Mr. Balbir was not entitled because we
So, my
already
lord, whenever in
discussed
Apple
this
there'll be a thumbs up or there'll be a victory sign, then balloons will come. That is the
Why
Apple
is Why
problem.
is it not happening now then? You did both.
So I have turned it off. So that there's no distraction.
Well, Mr. Balbir, you must have done it there.
Yeah, possibly. So grateful, my lords. My lords, we'll have it on the last day of
Yes,
vacation.
yes, 29.
I'm so grateful, my lords.
Grateful.
Deeply grateful.
59. You are for?
My lords, I'm an intervener in item number 15.
These applications now,
Dismissed all.
to begin with, other concessions in para 49 would have application only to disabled candidates. The sentence does not lend itself to the interpretation that other concessions should be extended to all untainted candidates. That's not how the sentence.
Lord, I'm appearing in 59. That is a contempt petition.
No, my lord, many applications were moved, my lord. Lordship was kind of to dismiss all. They're trying to, my lord, create trouble by making
we
these
never-
applications.
we
That
never
is my
said
submission
that
also. I am in 59.1. This is a
Lord, I'm
complete
not-
different.
59.1, I'm for the petitioners. Lord, 59.1. May I submit, Lord, with great respect. Lord,
Is-
this is one selection where all the well accepted norms of recruitment have been transgressed.
No, we are not arguing the main case here, no.
All over now. Case is already
We are not
taken.
arguing the main case.
May I?
Question
We're
is
not
whether
going
there
to
is.
reopen
My lord,
anything.
I'm
All
present
these points were
I'm
argued.
listening to persons, my
185
lord.
review
However many
applications were
people you may be
dismissed.
That in the
representing,
contempt matter,
I'm not
I
in
am
any
appearing in
inquiry
the
panel, my lord.
contempt
if
matter. I
you're
am
not
not
there, you're
saying
not there.
anything.
You were
Malas, I'm
arguing.
representing a teacher, Malas. He's
If
75%
you
blind,
not,
Malas.
if you
He's
not
57
participate
years
in the
old,
next
Malas.
section,
That is the
Malas,
contempt
Malas, therefore, Malas, we
matter.
want to have a clarification on the concerns, Malas.
that's what they
Listed me in a
75%
list of
blind, Malas, and
expired
Malas,
persons,
57-year-old,
Petitions
Malas.
are pending.
I'm not
Malas,
No,
we want
all
the
these
contempt.
points were
I'm asking you
argued
the
long
clarification,
back.
Malas.
Milord, may I submit with great
we
respect?
find no grounds to entertain
Yes.
these applications filed for clarification. What are they called? Clarification of the judgment dated.
Malas, may then allow me to withdraw the
2025
application for clarification, Malas.
Ardeep Loveless.
2025 and
persons
batch.
who are asking for clarifications, my lords. I'm not for them. I'm against them because they have listed me in a list.
Milord, first
where
of all,
I'm
there is
being
a
shown
contempt
as a
petition.
tainted
Milord,
candidate, my lords. I'm
That-
not.
the contempt petition first.
There's no question of our going into it because that issue was never before us.
Go down to that, my lords. I
If you had raised the only one candidate who did have a case in that
my lords, my lords.
Yes.
Very well, my lords.
in that issue on that issue was a person who had filed a writ petition even before the closure of the case by the Calcutta High Court itself.
My lords.
Right,
That
right.
was the only case we said her case alone requires to be examined because we never went into the issue as to who is tainted, who is not tainted.
Exactly, my lords.
So if you have a cause in that regard, you ought to have raised it prior to this happening.
Absolutely.
My lords.
Because before us, everyone was certain as to whether they were tainted or not tainted.
Totally agree with
Because
you,
they
sir.
all
That is
council
why,
all
Lord, we are
spoke
in
and
con-
we
we
are
are in
for
a
the
contempt
untainted
petition.
candidates. Now you can't say that there was a doubt and we want to reopen that issue now. Sorry.
Absolutely right, Milord.
That
Your
as a
lordships
matter
will
of routine, these
observe that
applications
till
are
the
filed
final
without
process
applications
is
are-
over, your lordships, no more
Malas, the
applications
issue
will
is,
come
Malas, they
to
have,
your lordships
Malas,
because this
Not in
delays the
one
process
59
all
point.
the time.
But can I
Let me
just
just say one thing.
can I just be heard?
Malas, the second issue is, Malas, the number
At
of,
the
Malas,
same time, I can't
candidates
make
for a
a
particular
single thing.
category that has
So
been,
we'll
Malas,
go
altered
with
by the,
ladies
Malas,
first. So Ms.
department,
Makija,
Malas.
yes.
Milord, 59.1 is the contempt petition.
Are you a lady? Mr. Masoodi?
Milord, 59. I
I'm
am
a lady. I said ladies first. Ms. Makija, go first.
all right, all right.
Yes, your lordships.
Yes,
Your lordships,
okay.
all that I'm praying for is that these applications and contempt petitions are repeatedly coming through different people, but on the same grounds. If your lordships may kindly till the time that West Bengal Service Board finishes their application should come, your lordships. They are all on the same grounds. On a previous occasion,
Stall the filing of applications.
your lordships may then observe that the recruitment must go on, your
That
lordships.
we have not stated. Where's the question of it not going?
There is no stay. There is no stay.
We can't stall the filing of cases. That's not right.
So,
Yes,
Yes, your
next.
lordships may kindly say that the recruitment be completed
That
as
these are
per
all
stated
frivolous
by your
applications.
lordships earlier, by 31st
Anyhow, we can't
August.
stop the
Lordships
filing
have
of
given
it.
that
Mr.
deadline.
Makija. Let's see what.
link has been sent to 800 people, my lords, who are listed wrongly in this clarification application, my lords. They have not listed an order that is dated 7th of 7/7/2023.
The later one,
Yes, my lord.
allowing the untainted candidates. to
This
continue.
list of 5757 people, my lords, where 2-3 recommendation letters are there. They have not attached the Gazette notification of 2016, my lords, and they are coming from.
Anyhow, we are not entertaining anything.
Obliged, my
Yes, Mr. Masoodi.
Lord, may I, with great respect, Lord, the transgression and the rampant illegalities which were noticed by the Honorable Supreme Court, Lord, I invite my Lord's kind attention to page 77 directly. It's a small paragraph, Lord. May I be permitted to read it out? The claim that the data on the 3 hard disks shows no interpolation and is consistent with the data in Messrs. Data so-and-so solutions computers fails to account for significant gaps and discrepancies. These issues highlighted in both the impugned judgment and our findings clearly point out to large-scale manipulation and tampering with results, including rank jumping, discrepancies in marks, the issuance of appointment letters to candidates not on the
What
panel.
do you want from that now?
Now, my lord, this is what has been noticed and what finally the Honorable Supreme Court, my lord, approved and affirmed the judgment rendered by the High Court. Now, our grievance is, my lord, I have taken up the matter in two parts. Now, these four categories, in paragraph 28, if your lordship may have at page 28, what I say is that the Honorable Supreme Court, with respect to the appointments, when it applied mine, it found that 6,276 candidates who were tainted were appointed and their appointments were quashed.
We never mentioned any numbers, but anyhow.
Yes, your lordship may kindly have the numbers are there in paragraph 26 of the.
If I can make a preliminary submission, these very people had first filed one IA before the registrar. The registrar refused to entertain it. They withdrew it.
Because there is a question which has come up as to the figures.
Just 1 minute. They have filed a second IA before your lordships and sought permission to withdraw it. And now this contempt, it's a misuse of the process.
No, it's not. It is simply we are not going for the multiplicity of proceedings which have ultimately been settled by the apex court in great clarity. No, my lord, the figures your lordships were pleased to ask me. Please kindly have not page 70. Page 70, your lordship may kindly have at the bottom. The figures are disclosed by the apex court in its judgment. Lord, last paragraph, Lord, in the last part of of this page 70, Lord, the apex court says, records that the commission claims that 57 group C and 107 group D selectees, appointees with OMR mismatch were not recommended or appointed. However, their names also figure in the list
Where are you reading?
appointed through rank jumping and out of panel.
Where are you reading, Council?
Page 70, Lord.
Page 70 of 59.1.
This is paragraph 26 of the apex court judgment and page 70 at the bottom, my lord.
Yes.
Where WBSCC claims. This is the commission, my lord.
Yes.
Now, my lord, in this paragraph, the last sentence begins. The commission admits that 1,000
Claims that 57 group. Then
An admission is not.
no, this is an admission of the commission.
acknowledges. We have not said anything.
Now, next page. Lord, on page
Acknowledges
71.
that so and so illegal appointments were made.
On page
We have
71.
never gone into the numbers
Right.
or decided who is tainted, who is not.
Kindly have page 71. Kindly have page 71. Please turn this page, my lord, then your lordship may have. Thus, excluding 239 candidates who fall under both OMR mismatch and other illegalities, Commission acknowledges that 6,276 illegal appointments were made.
That's the commission's
Now,
acknowledgement.
Out of this 6,276, what they have done is what I have stated in paragraph 26.
Final judgment.
At page 28, out of these 6,276, they have notified the illegal appointments,
26
confining them, tainted candidates, confining them to 5,318. And 958 candidates are nevertheless.
We have already said that all issues will be raised before the High Court. So where there's no
That
question
is
of
for
again
the-
coming back.
They have raised
are
it,
filed.
the writ has already been dismissed. They raised this petition, they filed a writ is dismissed.
Oh, writ is
They came in SLP dismissed.
On 1875 application,
Either the
Candidates
all these
are
were
dismissed.
or the
Last
contempt case
clarification,
filed.
kindly dismiss this
My lords,
application.
if I just,
Judgment.
my lords, if I just,
2025.
one last submission on the
Two
clarification.
contempt petitions, Lord, regarding the same
4800
judgment.
of 2025 and
Notice
batch.
was
The
issued.
applications as well as the contempt petitions are accordingly dismissed.
Very
The
obliged.
original contempt is pending.
My
which
lords,
is
if
why
I
we
just
ask,
may-
why this contempt again?
The contempt petition is pending before this court.
That is for a totally different issue. It has nothing to do with this.
No.
These contempt petitions,
money
they are
return.
dismissing. They're in.
my lords, if I just may mention item 59.3 I pair for the applicants in that matter. We circulated a withdrawal letter on Friday. That is on
What exactly is
16th
that?
of
Is
May.
it an application or a contempt petition?
Same application, Your
It's an
Lordship.
application, the same as contempt.
Seeking clarification, my lord.
Right.
We
That's
wish
an
to withdraw. We
application.
circulated a
have
letter on
filed an
Friday.
intervention application in that clarification application, my lords.
You filed an
Yes,
intervention.
my lords. And
So
that
now they
This
may not want to withdraw
My
it now.
lords, with due respect, I would just submit that we've not gone into the merits of the case, therefore they have no locus.
We are not going to give you any liberties. Be
Yes.
certain about that.
Your Lordship may kindly bear with me for a second. The same contempt matter on one facet of
This
the
main
same
application
judgment,
with
my lord.
MA. This is the IA in MA number 26462 of 2026, Mr. Varun Rawat, Learned Counsel, representing Mr. Jain Nami. This Mr. Jain
Miss Namisha-
Namisha Anuj. Man or woman?
Woman,
Namisha
sir.
Anuj Jain, my lords. Namisha Anuj.
Oh, it's Miss Namisha Anuj
Miss
Jain.
Namesha.
Miss Namisha Anuj Jain seeks permission to withdraw the application filed for clarification. The application is permission granted. The application is accordingly dismissed as withdrawn.
Very grateful, Your Lordship.
Lord, the last submission, Lord,
Grateful.
Your Lordship may kindly have page 401. Just for
Your matter is already over, Mr.
just
Mukherjee.
one second, my lord, if Your Lordship.
Are deeply obliged, Lord. Lord, the
Yeah,
application
One
will be
minute
over.
indulgence, if
Very
Your Lordship
grateful,
may
my
kindly grant.
Grateful to your lordship.
Over now.
Grateful.
That's all. Item 60.
Please allow us to appear physically, my lord. It's
Yes, Mr. How did you get here?
but we were in chambers.
How did you get to the chamber?
Is not prohibited. Even your lordship's doors are open. Since we were in chambers, some other councils were repairing. My friend has
So-
come from Bangalore. He thought that we should go there.
Everybody is driving to the chambers within the Supreme Court, but you're not coming inside and arguing, is it? What is the logic? I thought the entire logic was nobody would come to the Supreme Court at all. But all of you have your offices here.
Full of cars.
Oh, I don't know what the point is. Anyhow, so you are here, you're here. All right.
We are grateful.
Yes,
My
Ms.
friend
Gupta.
Bangalore, he wanted to, my lords, come physically, so we are.
Yes.
Now, my lords, please have page 227. Lords, I have an eviction decree against me. The
But
mean
this
profits-
affidavit that you file, you try to be a little too smart for your own good.
I'm not.
If the High Court says file an affidavit saying that you're going to vacate these 16 rooms, you can just say pursuant to that order, I'm vacating. Why do you have to say this is only because out of respect for the order of the High Court, this does not foreclose my rights? Your appeal is pending anyhow.
Clarify.
So why do you say all these things?
Is right, but I want to clarify. If after this chronology, if your lordship feels that we have to change our affidavit, we will.
Look
Please-
at your affidavit once, 238.
Can I show 227 once? Permit me, my lord. What did the
227.
Honorable High Court 227? That's 18th December 25 order against which my SLP is dismissed. So I want to show this order, my lord. Now, in a first appeal, I am asked to file an affidavit to vacate before adjudicating the appeal. But that's all right, my lord. Please see the last 4 lines. The admitted rent shall be paid on or before 5th of every month. This order is without prejudice to the contentions of the parties. The appellant shall place on record the affidavit in terms of this order within 3 weeks from today. The affidavit had to be without prejudice, my lord. My first appeal is pending before the Honorable High Court. Now, my lord, I come to your lordship. Your
The
lordship
order already records it. Why do you have to say it in your affidavit again?
something else. Now, I'm saying something else, my
So
lord.
this order records that whatever you do is going to be without prejudice to the contentions.
So the prejudice I will show. Just give me one more second. My lord, in all fairness, your lordship dismissed our SLP against this order at page 235. Because we were wanting to say that, my lord, the appeal cannot be prejudged during pendency of my eviction.
You're a sublessee. You're a sublessee. And your lessee's lease is over.
No, not yet.
That is over 26 June, end of
But
June.
he has not said that Papanna has, my lord, instituted any suit against him, who is his lessor. So, my lord, now please see, after your lordship dismissed my SLP at page 235, I have filed the affidavit, my lord, at page 238.
Now
I
look
was
at
not
your
there.
affidavit, please.
Yes, my lord. Affidavit.
Not once, but again and again.
What does a party do? My lords, I am in an eviction.
Why
appeal.
do you have to do that? Anyhow, you are abiding by the order. Otherwise, the delivery warrant is already issued in the execution petition.
Stay in my favor since the time
So you
I filed
want
the
the
appeal.
stay is conditional, then you have to abide by the condition. You can't again bargain over the condition and say that I'll file an affidavit, but I'll do it on my own terms.
Problem today. Let's please appreciate our problem.
Extend.
Let's please, I'm sorry. Please appreciate the concern of a litigant. He is in an eviction appeal. He said that before deciding your appeal, you have to file an affidavit to vacate. Now, my lords, even that I have filed, but
Now, what happened on the next day? 3 days time was given. That was long ago.
I have filed the affidavit. Now, please see the impugned order. I want to show my concern, Lord. What
impugned order?
Page 2. Page 2, my lord, is the
Page
impugned
2
order.
is the 22nd April order, which gave you 3 days time to file a better affidavit. You've not filed it.
Lord, I want to show one thing. Lord.
No, did you file it pursuant to this?
Affidavit, because we have come to your lordships immediately. But please have my concern. Now that I've told all of this to your lordship, please have my concern. What does the Honorable High Court do? Lord, please have para 2 of this order. The affidavit by way of undertaking filed by appellant dated 25/2 is not in compliance with the directions of this court. Not the Honorable High Court also said without prejudice. Therefore, I added without prejudice. Let a fresh affidavit fill. Now, please see para 4. List on 13 July 26. And I am asked to vacate by 30th of June 26. Lord.
You have to vacate.
No, but Lord, my appeal having not
You
been...
can always go back into the premises again if you win.
This is not possible.
No,
Now, Lord, my request is twofold.
You're running a hotel anyway.
Restore your possession.
Sorry, my lord.
You think the High Court will not be able to restore your possession?
I'm not saying that.
You're running a hotel anyway. It's not like it's a...
But my lord, 48 rooms I already have out of those 16. Now, my lord, in all my humble submission, this is unheard of. Your lordship will never pass this order that in an eviction appeal, if your
Once
lordship...
the High Court imposes a condition, you are expected to abide by that order. All that you had to say was in terms of the order dated so and so, I'm filing the affidavit.
Lord, I
You want to be smart about it and say all these things, then obviously you are rubbing the High Court the wrong way.
This background I have given not for notice. I just want one single
Nothing more,
sentence.
Mr.
Lord, our concern, lordship may hear and then lords dismiss. The concern is this. Lords, I will file a better affidavit. I will file an unconditional affidavit. Lords, the Honorable High Court is reopening on 1st of June. Since I have been asked to vacate on 30th of June, there are 30 days, Lords. Let my appeal be decided at least in the first week of June.
We are not going.
Lords, otherwise, Lord, this puts the cart.
We are not going to fix a time.
Where does the litigant go? Lords, I am just wanting to say
You
that.
want a stay, is it not? Otherwise, the
Don't
execution
give us
can
a stay.
go on.
I have a stay. Till 30th of June, High Court has not asked me to vacate.
But restored into possession. Put out.
Lords, but in an eviction suit, after having given
Find
me
no
a
good
stay,
ground and reason to interfere with the impugned interim order passed by the High Court. Especially petition is accordingly dismissed. The petitioner shall file an affidavit as directed by the High Court within 3 days from today.
you will do that. And Lord, then lordship may at least...
Nothing more.
No, before 30th of June, Lord,
We're giving you 3 more days. Be happy about
but
that.
equities have to be balanced. Lord, and
That is the equity. You get 3 more days time, though you did not file it within that time. 25. You can file it
get a
immediately.
stay on deposit of 75%. I deposit that, Lord.
Nothing more, Mr. Gagan.
Now, without a modification application, this stay order is modified to say that you file an undertaking before my appeal getting adjudicated. Lord, this in my...
File it, please.
Lord, this is
Nothing more. Nothing more at this stage.
No, Lord, nothing.
Nothing more at this stage.
For a tenant to come back, Lord, in the premises, Lord, is...
You're a sublessee whose lessor's lease is running out. Where's the question?
30 years and I'm running a hotel. These are meant to be long-term leases.
Very good.
Now, Lord,
Nothing
I have
more.
my remedy until this honorable court. I
This
can't be
lease
shut
deed
down.
is of 12th January 1990.